Gary Wall here, and this is Bridging the Weeks for November 23rd to December 4th, and today is December 7th, 2015. Good morning. Compliance officers may be in the bullseye again as a result of new regulatory proposals introduced during the prior 2 weeks by the New York State Department of Financial Services and the Commodity Futures Trading Commission. Meanwhile, another compliance officer put himself in the bullseye of the Securities and Exchange Commission by purportedly trading on confidential information he was entrusted to safeguard by his employer and not to profit from. We have a lot to cover this week after our 2-week absence, so let's get started. Last week, the Commodity Futures Trading Commission brought and settled its first enforcement action sounding in the securities concept of insider trading, relying on the relatively new Dodd-Frank Wall Street Reform and Consumer Protection Act's prohibition against employment of a manipulative or deceptive device in connection with futures trading. According to the CFTC, from September 3rd through November 26, 2013, Ira Montezedi, a gasoline trader employed by an unnamed large publicly traded corporation, misappropriated, quote, non-public, confidential, and material information, end of quote, of his employer to benefit his own trading of energy futures contracts listed on the New York Mercantile Exchange. Specifically, on 34 occasions, Mr. Montezedi allegedly traded opposite his employer's account to effectively transfer profits from the firm to himself, and on 12 occasions, he traded in advance of orders he placed for the firm to generate, quote, additional profits for himself to the detriment of the company, end of quote. The CFTC claimed that Mr. Montezedi owed a duty of confidentiality to his employer that he breached. To resolve this matter, Mr. Montezedi agreed to pay restitution of almost $217,000 US to his employer and a fine of $100,000 US, and agreed to be permanently banned from trading CFTC supervised products subject to the rules of a registered trading facility. On the same day the CFTC action and settlement was announced, the CME Group and Mr. Montezedi also settled this disciplinary action brought by the New York Mercantile Exchange related to the same essential facts at issue in the CFTC matter. The New York State Department of Financial Services has proposed new tough anti-money laundering and financial crime prevention regulations for New York State regulated banking entities, as well as certain non-bank entities, including check cashers and money transmitters licensed under New York's banking law. Under proposed new rules, affected entities must have enhanced transaction monitoring and filtering programs that, quote, reflect all current AML laws, regulations, and alerts, end of quote, and that are designed to stop transactions that are prohibited by U.S. government sanctions programs. They must also have processes to help ensure their transaction monitoring and filtering programs utilize accurate data from all relevant sources. Moreover, on an annual basis, the Chief Compliance Officer or functional equivalent of an affected entity must certify under oath that the firm's transaction monitoring and filtering program complies with all provisions of the new regulation. Wow, this is a tough proposal. The new proposed rules will be subject to a 45-day comment period after their publication in the New York State Register. An ex-compliance officer of Goldman Sachs was charged by the Securities and Exchange Commission with trading on confidential inside information he was entrusted to use for internal surveillance purposes, not for proprietary gain. According to the SEC, from July to October 2015, Wei Han was employed by Goldman Sachs as an associate in its surveillance analytics group within the company's compliance department. In connection with at least 4 companies Goldman Sachs advised on mergers and acquisitions, Mr. Han traded for his own account or that of an apparent relative in China based on information he accessed as a result of a position with the firm, charged the SEC. In October 2015, before this case was filed, Mr. Han left Goldman Sachs and the United States and is believed now to be in Shanghai. The SEC seeks an asset freeze, an injunction, disgorgement, and a fine against Mr. Han, as well as Wei Han, the apparent relative whose account Mr. Han traded. The Public School Pension and Retirement Fund of Chicago filed a purported class action lawsuit against 12 swap dealers and, in some cases, certain of their affiliates alleging they conspired to prevent interest rate swaps from being traded on exchanges. To support its allegation, plaintiff claimed, among other things, that respondents worked together to coerce interest rate swap execution facilities, quote, to allow only a request for, quote, trading method, end of quote. According to the plaintiff, executing trades through an RFQ functionality is equivalent to executing a trade opposite a dealer over the counter. Plaintiff also alleged that respondents, quote-unquote, jointly agreed to boycott CEFs, quote, that took steps to permit buy-side to trade IRS on electronic platforms outside of the dealer defendant's control, end of quote, and, quote-unquote, force CEFs to require the, quote, disclosure of identity of every swap counterparty to the other on every trade, end of quote. The plaintiff filed its lawsuit in a federal court in Manhattan. Separately, the European Commission announced it had closed antitrust proceedings against 13 investment banks related to credit default swaps trading. Previously, in 2013, the EC had raised preliminary concerns that the banks, quote-unquote, had coordinated to prevent Deutsche Börse in 2007 and the Chicago Mercantile Exchange in 2008 from offering a CDS marketplace. The EC said it is still investigating the actions of Market and the International Swaps and Derivatives Association in connection with this matter. And finally, the Commodity Futures Trading Commission proposed a comprehensive set of new rules that, if adopted, potentially would impose many new obligations on certain CFTC registrants that use automated or algorithmic trading systems to trade futures, options, or swaps on designated contract markets. Potentially impacted registrants are futures commission merchants, floor brokers, swap dealers, major swap participants, commodity pool operators, commodity trading advisors, introducing brokers, and certain persons proposed to be registered as floor traders for the first time because of their automated or algorithmic trading activities. FCMs who are clearing members of DCMs and carry account for covered algorithmic traders, DCMs but not swap execution facilities, and the National Futures Association would also be impacted by the CFTC's proposed new requirements. I have an extensive article on these proposed new regulations on the webpage at www.bridgingtheweek.com. Check it out. Well, that's it for this week's Bridging the Week. As always, there is much more information in each article, and more articles on the article version of Bridging the Week on the website. Did I say it? Check it out. Until next week, this is Gary DeWall. Have a great week, and ciao!